What's up, shitheads? The sentencing memorandums for the Duggar case are in. The government is asking for the max of 20 years, which is totally normal and to be expected. And of course, the defense is asking for the minimum of only 5 years, which again is totally normal and to be expected. On today's episode, I'm going to be reading to you guys the government's sentencing memorandum. Comes now, the United States of America by and through Dustin Roberts and Carly Marshall, Assistant United States Attorneys for the Western District of Arkansas, and William G. Clayman, Trial Attorney for the United States Department of Justice, and files its sentencing memorandum for all matters relevant. The government states the following. Overview and sentence recommendations. On or about April 28, 2021, the defendant, Joshua James Duggar, was named in a 2-count indictment filed in the Western District of Arkansas. The indictment charged Duggar with receipt and possession of child pornography. On or about December 9, 2021, after an approximately 8-day jury trial, Duggar was convicted on both counts. Thereafter, the court accepted the jury verdict, ordered a pre-sentencing report to be completed, and remanded Duggar into custody. The offense conduct overall reflects that Duggar, over a 4-day period, set up a hidden partition on his work computer and installed both the Onion router, Tor, sometimes referred to as the dark web, browser, and separately a BitTorrent peer-to-peer file sharing client on the partition in order to download and view child pornography. At present, the United States probation's calculation under the United States sentencing guidelines set out in the final PSR reflects an advisory range of imprisonment of 360 months to life, which will be capped by the offense maximum of 240 months set by statute for count 1 in the indictment. The government made one guideline determinative objection to the initial PSR regarding the total image count and multiple objections clarifying Duggar's offense conduct, all of which have been remedied in the final PSR. The defense objected to 85 of the 168 paragraphs in the initial PSR, including but not limited to all offense conduct attributed to Duggar set out in paragraphs 25 through 88. All prior acts of sexual abuse committed by Duggar set out in paragraphs 99 and 114, and the application of the following enhancements under the guidelines. The 2-level distribution enhancement under USSG 2G2 2B3F, the 4-level enhancement for visual depictions of sadistic and masochistic conduct under USSG 2G2 2B4, the 5-level enhancement for engaging in a pattern of activity under USSG 2G2 2B5, and the determination of the number of images involved in the offense, which he contends is 127 images and therefore requires the application of the 2-level enhancement under USSG 2G2 2B7B. The final PSR correctly applies these 4 enhancements over the defendant's objections. With respect to the defense objections, the government submits that the conduct established at trial supports the application of all contested enhancements and establishes that the offense involved 600 or more images, warranting the application of a 5-level enhancement under USSG 2G2 2B7D as correctly reflected in the final PSR. Accordingly, the applicable total offense level under the guidelines should be 42. Side note, when they say that applicable total offense level under the guidelines should be 42, this is the feds and they have a point system and that's how they calculate sentencing. So 42 is the number that they have calculated and that's based on the crime, elements of the crime, prior history, prior convictions, yada, yada, yada. Now back to it. which would call for a sentencing range of 360 months to life based on Duggar's placement in criminal history category 1, capped at the 240-month maximum sentence permitted by statute in count 1 USSG 5G11A. While the facts established at trial provide a sufficient basis to overrule all pending defense objections to the offense conduct and support the PSR's guidelines calculation, the United States could potentially call Special Agent Gerald Faulkner, U.S. Probation Officer D.M. Nugent, and, if necessary, Springdale Detective Daryl Hignite as witnesses during the sentencing hearing, currently scheduled for May 25, 2022. Their testimony would take approximately 1 hour. Based on all the facts of the case, including Duggar's prior sexual exploitation of multiple minors discussed herein, and in consideration of the extraordinary efforts Duggar took to obtain and view child sexual abuse material, the nature of the scam he obtained and viewed, his efforts to conceal his criminal conduct, and his refusal to take accountability for or acknowledge any of his criminal conduct, the government recommends the court impose a guideline term of imprisonment of 240 months. Pending guidelines objections lodged by the defendant. Duggar has raised a litany of objections to the enhancements in the PSR, primarily arguing that the evidence is insufficient to support their application under the guidelines. For sentencing purposes, however, a court need only find facts by a preponderance of the evidence and may consider any relevant information, even if it would be admissible at trial, provided that the information has sufficient indicia of reliability to support its probable accuracy. In other words, to apply a sentencing enhancement, a court need only find that it is more likely than not that the defendant engaged in the requisite conduct based on all relevant information. As discussed below, the evidence presented at trial and in pretrial hearings is more than sufficient to satisfy the preponderance of the evidence standard with respect to all the sentencing enhancements in the PSR, and Duggar's objections should be overruled. The enhancement for distribution of child pornography. Duggar first objects to the application of the two-level distribution enhancement pursuant to USSG 2G2, 2B, 3F. In support of his objection, he claims there was absolutely no evidence that Duggar knowingly distributed any materials. Despite such claim, the evidence introduced at trial establishes that Duggar was a very savvy computer user who was familiar with peer-to-peer file sharing programs and the Tor network, had personally installed such programs on his computer as part of his offense conduct, including the uTorrent peer-to-peer file sharing software he used to download Scam, and through which he distributed Scam to Detective Amber Calmer, and had a long history of utilizing these same or similar file sharing programs on his personal laptop to download material from others. Given the evidence of Duggar's sophisticated understanding of peer-to-peer programs and computers generally, the two-point distribution enhancement is correctly applied. As an initial consideration, Duggar notes, in lodging his objection to the distribution enhancement, that he was not charged with distribution. The guidelines, however, clearly permit the consideration of non-charged conduct in applying the enhancements, specifically USSG 1B13A relevant conduct factors that determine the guideline range states, unless otherwise specified, The base level, where the guideline specifies more than one base offense level, specific offense characteristics, and cross-reference in Chapter 2 and adjustments in Chapter 3 shall be determined on the basis of the following: all acts and omissions committed, aided, abetted, counseled, commanded, induced, procured, or willfully caused by the defendant. Turning to the substantive objection lodged by Duggar, he claims the distribution enhancement is misapplied because the evidence does not reflect that he knowingly distributed child pornography. As applicable here, USSG 2G2 2B3F calls for a 2-level enhancement if the methods of distribution outlined in 2G2 2B3AE do not apply. Application Note 1 of the same section defines distribution as any act including possession with intent to distribute, production, transmission, advertisement, and transportation related to the transfer of material involving the sexual exploitation of minors. The Eighth Circuit has provided ample guidance on the application of this provision of USSG 2G22, all of which supports its application here. In United States v. Dodd, for example, the Eighth Circuit held that, absent concrete evidence of ignorance, a fact finder may reasonably infer that a defendant knowingly employed a file-sharing program for its intended purpose, namely to share, or in other words, to distribute. Similarly, in United States v. Durham, the Eighth Circuit held that if a defendant uses a file-sharing program, a fact finder may reasonably infer he intended to distribute files unless there is concrete evidence of ignorance. Consequently, the 2-point enhancement should apply in cases where the defendant had knowledge of computers and file-sharing programs. See United States v. Glasgow. Distribution enhancement applied where the defendant built the computer used to download child pornography, as well as uploaded and downloaded files and programs. See also United States v. Esty. Distribution enhancement applied where the defendant placed an internet peer-to-peer file-sharing program on his computer, knew how the program operated, and shared images with other network users. In this case, without question, Duggar factually distributed scam through a peer-to-peer network. On May 14th and May 15th, 2019, Detective Amber Calmer downloaded via the BitTorrent file-sharing network the files MOV_0216.mp4 and Marissa Zip, respectfully from Duggar at his car lot. As introduced and published to the jury at trial, the video file and many of the images from the Marissa Zip file depict child pornography as defined by federal law. Forensic evidence introduced at trial likewise established that this video and these images were not only downloaded by Duggar, but viewed by him on his computer located on the car lot. Side note, shitheads, that the next paragraph is about to reference our computer forensic computer genius bestie Clint, so we're going to have to take a minute to give him a round of applause. Okay, proud to know you, Clint. Now let's get back to business. Turning to the evidence supporting Duggar's knowledge of how a peer-to-peer program works, of importance, government witness Clint Branham, a cybersecurity expert who testified that he had known Duggar for approximately 20 years, describes Duggar's computer abilities as being that of a power user, denoting someone who is more advanced with computers than the average user. Per Branham, a power user like Duggar can install programs, modify hardware, and, if need be, install hardware or build their own computer. A power user like Duggar, in Branham's estimation, may also know how to write their own computer code and use command line prompts. Another government witness who had also known Duggar for years, Jim Holt, likewise testified about Duggar's advanced computer skills. Specifically, Holt testified that Duggar edited commercials and produced literature and graphics for Holt's political campaign as a teenager and was familiar with the concept of a Linux partition as far back as 2004. Supporting Branham's and Holt's testimony, Duggar's offense reflects that he is a highly sophisticated and experienced computer user. Notably, prior to downloading Scam, Duggar downloaded and installed a Linux partition on his work computer in order to circumvent the internet monitoring software Covenant Eyes installed on the default Windows partition of the computer. The act itself is reflective of not only Duggar's ability to install computer programs, but also his elevated understanding of computer operating systems and how operating systems and computer programs work in order to circumvent such. Thereafter, Duggar downloaded, installed, and utilized both the Tor browser and BitTorrent peer-to-peer file sharing programs on the Linux partition side of the computer to obtain Scam. With respect to the installation of the Tor browser and the BitTorrent client program, it is Duggar's position, per his own computer expert, that he would have had to use command line prompts to do so, which, by her estimation and per her demonstration, requires a high level of computer sophistication and is akin to speaking another language. In fact, a major theme of the defense at trial was that the individual who committed these crimes is a very sophisticated computer user. In other words, even under Duggar's theory of the case that was rejected by the jury, he possessed all the requisite knowledge to understand that his use of peer-to-peer programs would distribute content to others, which is consistent with Branham's and Holt's description of Duggar based on their decades-long relationships. Finally, it is significant in gauging his knowledge of how peer-to-peer programs work that Duggar has a history of using or attempting to use peer-to-peer programs dating back to at least 2017. At trial, the government's forensic expert, Director James Futrell of the High Technology Investigative Unit in the Department of Justice, testified that peer-to-peer programs were installed and used to download movies on Duggar's personal MacBook seized by law enforcement. Additionally, Director Futrell located evidence in the form of Covenant Eyes reports that Duggar tried on 2 occasions in April and May of 2017 to download the exact BitTorrent client, namely uTorrent, that he used to obtain Scam in this case. Finally, Director Futrell testified that Duggar not only had the Tor browser installed on his iPhone, but that he was using it the very day his car lot was searched to view pornography. In summary, the above facts established at trial reflect that Duggar is a very sophisticated computer user with a history of downloading, installing, and utilizing peer-to-peer file sharing programs, and an understanding that his use of those programs would, and indeed did, result in the distribution of material to others. Given the total absence of concrete evidence of ignorance on the part of Duggar, the 2-level distribution enhancement should apply. The enhancement for material that portrays sadistic or masochistic conduct or other depictions of violence. Can I have your attention? Great, glad I got your attention. Listen, if you're listening to this podcast right now, based on the title of this section, you already know that this is a trigger warning section. They are clearly about to be discussing why they think that this case should have the enhancement for material that shows sadistic, masochistic, or violence in it. So we are clearly about to be discussing evidence that validates their claim for why that enhancement should be applied here in this case. So we are going to be discussing evidence that will be triggering. If you do not want to hear it, I recommend fast forwarding about like 5 minutes ahead. Next, the defense objects to the application of the 4-level enhancement pursuant to USSG 2G2 2B4, which applies in cases where the offense involved material that portrays sadistic or masochistic conduct or other depictions of violence, or the sexual abuse or exploitation of an infant or toddler. In lodging their objection, the defense simply claims the evidence does not even arguably support the application of this enhancement. Notably, despite his current objection, the defendant sought a pretrial ruling prohibiting law enforcement witnesses from commenting on the graphically violent nature of certain material at issue in this case as compared to other scam. Duggar's bare-bones objection to this enhancement should be denied because the evidence produced at trial, which included visual depictions from Duggar's computer of prepubescent girls being vaginally penetrated and bound with rope, easily satisfies the requirements to apply this enhancement. See United States v. Parker, holding that images of the sexual penetration of a minor girl using a large carrot were depictions of violence or sadism, warranting the 4-level increase in 2G2 2B3. See also United States v. Diaz, finding that images showing an adult male engaging or attempting to engage in intercourse or oral sex with a minor were included within the previous scope. United States v. Hall, holding that images showing vaginal or anal penetration of a prepubescent minor by either an adult male or a foreign object is sadistic within the meaning of 2G2 2B3. Sick fucking pieces of shit wasting our fucking oxygen supply, I swear to God. As its first witness at trial, the government called Detective Calmer and introduced via her testimony Government's Exhibit 3, which contains the 2 files Duggar distributed to law enforcement in May of 2019, namely MOV_0216.mp4 and Marissa Zip. With respect to the MOV_0216.mp4, file downloaded on May 14th, 2019, this video depicts, among other things, the vaginal penetration of 2 prepubescent females by the erect penis of an adult male. Government's Exhibit 3 at approximate 1 minute and 20-second mark, said video and the identified section was published to the jury. With respect to the Marissa Zip file on Government's Exhibit 3, the zip file contains 65 images depicting an approximately 7 to 8-year-old female, including the following. Image 2400, located on page 3 of Exhibit 3A, which depicts a very young prepubescent female being vaginally penetrated by an erect adult penis. Image 2349, located on page 3 of Exhibit 3A, which depicts the very young prepubescent female forced to perform oral sex on an erect adult penis. Image MAR 37010, located on page 6 of Exhibit 3A, which depicts a close-up of a very young prepubescent minor female being anally penetrated by a dildo, and image MAR 37004, located on page 6 of Exhibit 3A, which depicts a close-up of a very young prepubescent minor female being anally penetrated by a dildo. At trial, the government also presented the testimony of Director Futrell, who confirmed that Duggar utilized his computer to download and view both the MOV_0216.mp4 file and the images from the Marissa zip file. Of note, Government's Exhibit 31, which contains the thumbnail images created when Duggar opened and viewed the contents of the Marissa zip file, includes thumbnail images of the same approximately 7 or 8-year-old described above being anally penetrated by an adult male's finger, anally penetrated by a dildo, vaginally penetrated by a vibrator, and locked in a cage. Additionally, the government introduced Exhibit 35 and 36, which, per Director Futrell, contained images of scam from the same Marissa zip file located in the unallocated space of Duggar's computer. Exhibit 35 contains approximately 39 images of scam depicting the same minor girl, including images of the minor lying nude on a bed with her legs spread apart to expose her vagina and her hands bound to the headboard, huddling nude while locked in a dog's cage and being vaginally penetrated by an adult male penis with her abdomen covered in a substance that resembles blood. Exhibit 36 contains approximately 220 images of the same minor recovered from Duggar's computer, including the images in Exhibit 35 as well as images of this minor lying nude on a bed with the words "cut me," "slut," and "hurt me" written on her in a blood-like substance and a knife pointed at her vagina, huddling nude in a cage, lying nude on a bed with her hands bound behind her back, and lying nude on a bed while being whipped with what appears to be a cat-o'-nine-tails whip. Lastly, the government introduced evidence regarding the torrent files recovered on Duggar's computer and the corresponding images or videos that can be downloaded using these torrent files through the BitTorrent network, including the following: the MOV_0216.mp4 torrent file downloaded on May 14, 2019, which Duggar used to download a video depicting the vaginal penetration of 2 prepubescent females. The DD torrent file downloaded twice on May 15, 2019, which is associated with video files titled DD BDSM2.mp4, Lux_leak3 mp4, Lux_leak4.mp4, PTHCOPVA 2013 rape, Ultra mp4, and Intro.dd.mp4. This file was described by Director Futrell as one of the most offensive series of scam that he has seen in his career, depicting adults sexually abusing a toddler, hanging the infant by their hands and feet, and dropping hot wax on the infant, and the AseMamaLinda.mp4 torrent file downloaded on May 15, 2019, which Duggar used to download a video depicting the vaginal penetration of a prepubescent female. What a fucking piece of shit. Like, what a royal fucking piece of shit. Based on the above cited case law and a review of the evidence produced at trial, the application of the sadistic masochistic enhancement under USSG 2G2 2B4 is warranted here. See United States v. Bellflower, holding that images involving the sexual penetration of the vagina of a minor girl or the anus of a minor girl or boy by an adult male are, per se, sadistic or violent. No fucking shit. Within the means of the guidelines. See also United States v. Corp, approving application of identical enhancement in 2G2.1, where material objectively depicts activity that is inflicting physical pain, emotional suffering, or humiliation on a minor. The defense's meritless objection to the application of this enhancement should therefore be denied. The enhancement for engaging in a pattern of activity involving the sexual abuse of minors. At present, Duggar objects to U.S. probation's inclusion of the 5-level enhancement pursuant to USSG 2G2 2B5 for engaging in a pattern of activity involving the sexual abuse or exploitation of a minor based on his prior molestation of multiple minors. Duggar argues that the court should find that these acts of molestation did not occur, and that even if they did, the court should disregard them because they occurred years ago. Contrary to Duggar's claim, however, evidence produced during pre-trial hearings and at trial, including the testimony of his father, Trash Bob Duggar, and his longtime family friend, Bobby Holt, reflect that Duggar engaged in the exact conduct he now denies occurred and is more than sufficient to support the application of this enhancement based on the preponderance of the evidence. Section 2G2 2B5 of the guidelines applies when a defendant engaged in a pattern of activity involving the sexual abuse or exploitation of a minor. Application Note 1 of the commentary to USSG 2G22 defines pattern of activity involving the sexual abuse or exploitation of a minor as any combination of two or more separate instances of the sexual abuse or sexual exploitation of a minor by the defendant, whether or not the abuse or exploitation occurred during the course of the offense, involved the same minor, or resulted in a conviction for such conduct. The term sexual abuse or exploitation is further defined to include, as relevant here, any conduct described in Section 18 U.S.C. 2241 or 2242. A state offense would be equivalent to these federal offenses if committed in an area of exclusive federal jurisdiction, or an attempt to commit any of these crimes. In the instant case, the United States elicited testimony both at a pretrial hearing held on November 30th, 2021, and at trial regarding Duggar's repeated acts of child molestation that qualify as the sexual abuse or exploitation of a minor under USSG 2G22. Specifically, the government called as a witness Duggar's longtime family friend, Bobby Holt, at the pretrial hearing and at trial. As relevant here, Ms. Holt testified that on March 30th, 2003, Duggar's parents, Trash Bob and Michelle, called her husband and asked for the Holts to come over to their residence. Holt testified that when they arrived, she, her husband, Duggar, and Duggar's parents all had a conversation. Holt testified that during that conversation, Duggar explained that earlier that day, Jane Doe 4 was sitting on his lap during Bible time, and he touched her inappropriately on her vaginal area over the clothes with his hands. Holt testified that Duggar also confessed that he touched the breast areas and vaginal areas of Jane Doe 1, Jane Doe 2, and Jane Doe 3, sometimes on the clothes and sometimes under the clothes. Holt elaborated that Duggar admitted to doing this to Jane Doe 1, Jane Doe 2, and Jane Doe 3 on multiple occasions, both when they were asleep and awake. As established during the pretrial hearing and at trial, in March 2003, Jane Doe 1, Jane Doe 2, Jane Doe 3, and Jane Doe 4 were all at least 3 years younger than Duggar. Holt testified that Duggar told her he had been touching these individuals since he was approximately 12 years old, which would have been in 2000 to 2001. Bobby Holt also testified that Duggar had another conversation with her regarding Jane Doe 4 in 2005. Holt testified that during that conversation, Duggar elaborated on his molestation of Jane Doe 4 on March 30th, 2003, explaining that he put his hands under her pantaloons and under her panties and touched her vagina. Per Holt, Duggar confessed to digitally penetrating Jane Doe 4's vagina. Also, at the pre-trial hearing, the government called as a witness Duggar's father, Trash Bob. while Trash Bob demonstrated a somewhat selective memory of the incidents at issue, he confirmed that Duggar inappropriately touched the 4 minor victims identified by Ms. Holt. Of importance, Trash Bob testified that in 2002, Duggar disclosed to him and his wife that he touched the 4 minors when they were sleeping, like on the breast, like over their clothes. They didn't wake up. Additionally, Trash Bob testified that Duggar's conduct eventually prompted them to contact and subsequently disclose Duggar's molestation to Bobby Holt and her husband. As the court determined in pretrial litigation, the corroborated and effectively unrefuted testimony of Bobby Holt is sufficient to establish by a preponderance of the evidence that Duggar did in fact engage in the above criminal conduct. Based on Ms. Holt's credible testimony, the court finds by a preponderance of the evidence that Duggar committed a previous act or acts of child molestation as defined by Rule 414. Of additional significance, and as the court is aware, in 2017, members of the Duggar family sued various Arkansas state and local law enforcement agencies in federal court for disclosing police reports documenting the sexual molestation at issue. Approximately 1 month after the suit was filed, Duggar, by and through his attorney Travis Story, who likewise represents him in this instant criminal case, sought to intervene and join the claims. Ultimately, Duggar withdrew his motion and filed a separate suit in federal court. In doing so, Duggar, by and through his counsel, again Mr. Story, included in his publicly filed complaint a statement of facts that Duggar attested to, verifying that all the statements were true and correct. Therein, the complaint specifically details that in 2006, members of the Duggar's family were interviewed by law enforcement and all made disclosures regarding instances of sexual abuse attributed to Duggar. In addition to claiming that his corroborated and well-documented confession to engaging in multiple acts of child sexual abuse is insufficient to support the pattern of activity enhancement, Duggar also objects to its application because his other acts of child sexual abuse occurred when he was a minor and did not result in a conviction. Despite Duggar's claims to the contrary, ample case law supports the application of the enhancement in these circumstances. In United States v. Woodard, for example, the Eighth Circuit denied the defendant's claim that his juvenile adjudication for second-degree sexual abuse could not form the basis for the enhancement. The court honed in on the 2 or more separate instances phrase of the enhancement, highlighting that the guidelines allowed for the enhancement whether or not the abuse or exploitation resulted in a conviction. The Eighth Circuit also emphasized that this enhancement contains no temporal limitations that would prevent the defendant's sexual abuse that occurred 19 years earlier from triggering the enhancement. All other circuits that have considered this issue have similarly held that a defendant's juvenile conduct involving the sexual abuse or exploitation of a child, even from years prior and even when based on similar testimonial evidence, was sufficient to trigger the application of the pattern of activity enhancement under the guidelines. See United States v. Alfano, applying enhancement in child pornography case based on decades-old incidents where defendant penetrated minors' vaginas at age 15 and touched half-sister's vaginal area at age 17. Consequently, the 5-level pattern of activity enhancement is correctly applied in this case based on the unrefuted and corroborated testimony of Ms. Holt, specifically Ms. Holt's testimony that Duggar admitted in 2003 to touching the vaginal area of multiple minors under the clothes and admitted in 2005 to digitally penetrating the vagina of a 5-year-old prove by a preponderance of the evidence that Duggar committed multiple acts of sexual abuse of a minor. More specifically, they constitute multiple instances in which Duggar attempted to and did in fact engage in conduct described in 18 U.S.C. 2241 and 2242 by engaging in a sexual act as defined by 18 U.S.C. 22462C and D with a minor. This evidence is also sufficient to establish by a preponderance of the evidence that Duggar attempted to and did commit sexual assault in the second degree. Codified at Arkansas Code 514125 and or rape codified at Arkansas Code 514103A3A, a conclusion that this court has already reached, at least in part. As such, the pattern of activity enhancement under USSG 2G2 2B5 is appropriately applied in this case. Additionally, while the government is not seeking an upward departure or variance in light of the correctly calculated guidelines range, it is clear that the United States Sentencing Commission envisioned a defendant's history of engaging in sexually abusive and exploitative conduct with minors, regardless of whether it qualifies for the enhancement under USSG 2G2 2B5, as being an aggravating factor for a sentencing court's consideration. Specifically, Application Note 9 of 2G2.2, entitled Upward Departure Provision, states, as relevant here, that if the defendant engaged in the sexual abuse or exploitation of a minor at any time, whether or not such abuse or exploitation occurred during the course of the offense or resulted in a conviction for such conduct, and the pattern of activity enhancement does not apply, an upward departure may be warranted. In addition, an upward departure may be warranted if the defendant received an enhancement under the pattern of activity enhancement, but that enhancement does not adequately reflect the seriousness of the sexual abuse or exploitation. The enhancement based on the number of images involved in the offense. Lastly, Duggar claims that his offense only involved 127 images and argues that the two-level enhancement under USSG 2G2 2B7A for offenses involving at least 10 but fewer than 150 images must therefore apply. Contrary to Duggar's objection, however, the evidence presented at trial proves that Duggar's offense involved over 600 images, warranting the application of the 5-level enhancement under 2G2 2B7D. Specifically, the evidence presented at trial established that Duggar used the Tor browser on May 14, 2014 to download a zip file titled Webcam Collections Perv 7Z, which contained approximately 33 images, if not more, and then extracted those images from the zip file into a folder on the desktop of the Linux partition. The evidence presented at trial further established that on May 15th and 16th, 2019, Duggar downloaded 11 torrent files associated with child pornography images and videos and used the uTorrent file sharing program to download the images and videos referenced in at least 9 of those torrent files. The list of the 11 torrent files, over 200 images, and at least 7 videos Duggar received in this manner are as follows. Trigger warning for titles of files. Duggar downloaded the MOV0214 file on May 14, 2019, obtained the MOV0214 video through uTorrent, and viewed the approximately 20-second video. Duggar downloaded the MOV0216 file on May 14, 2019, obtained the video through uTorrent, and viewed the approximately 2-minute and 12-second video. Duggar downloaded the 14-year-old girl suck and fuck file on May 15, 2019, obtained the 14-year-old girl suck and fuck video through uTorrent, and viewed the approximately 3-minute and 30-second video. Duggar downloaded the test.avi.torrent file on May 15, 2019, obtained the test.avi video through uTorrent, and viewed the approximately 1-minute and 10-second video. Duggar downloaded Pussy Pounded file on May 15, 2019, obtained the Pussy Pounded video through uTorrent and viewed the approximately 2-minute and 46-second video. Duggar downloaded the Play Toy Sweetie video file on May 15, 2019, obtained the Play Toy Sweetie zip file through uTorrent, and attempted to access the file through the VLC player on the Linux partition. Twice on May 15, 2019, Duggar downloaded dd.torrent file, which is associated with 5 video files titled dd.bdsm, lux_leak, lux_leak4, PTHC OPVA 2013 rape ultra, and intro DD. Duggar downloaded the Ase Mama Linda file on May 15, 2019, obtained the Ase Mama Linda video through uTorrent, and viewed the approximately 12-minute video. Duggar downloaded the Marissa zip file on May 15, 2019, obtained the Marissa zip file through uTorrent, and extracted at least approximately 58 images from the zip file into a folder on the desktop of his computer, which approximately 215 images from the Marissa zip file found in the unallocated space on his computer. Duggar downloaded the Pedomom file on May 16, 2019, obtained the Pedomom video through uTorrent, and viewed the approximately 30-minute video. That Duggar attempted to delete some of the files after viewing them, and that some of these files were identified through, among other forensic evidence, thumbnail images from Duggar's computer as a result, is of no consequence here. The Eighth Circuit addressed a similar scenario in United States v. Nissen, in which the government presented evidence that thumbnail images recovered from the defendant's computer reflected that 40 to 50 videos of child sexual abuse associated with those thumbnail images had at one point existed on that computer and were played by the defendant. These facts, the court determined, were sufficient to support the inference that the defendant's offense therefore involved more than 600 images. See also Glasgow, applying number of images enhancement over defendant's objection that he should not be punished for the total number of images because he tried to delete them. United States v. Ardolph, an image counts for purposes of the guidelines if Ardolph possessed it at some point. United States v. Pocken, affirming application of enhancement based on deleted images found in unallocated space. The facts adduced at trial prove that Duggar's offense conduct involved over 600 images based on the hundreds of images and at least 7 video files discussed above, and the court should follow the Eighth Circuit's guidance in Nissen and apply the 5-level enhancement under USSG 2G2 2B 7D here. Application of the 3553A factors. After calculating the applicable guidelines range, a sentencing court must consider that range, as well as the sentencing factors set forth in 18 U.S.C. 3553A, and determine an appropriate and reasonable sentence. Nelson v. United States. Based on the facts of this case and as described below, the government submits that a guidelines sentence of 240 months is sufficient but not greater than necessary here. In May of 2019, an Arkansas Internet Crimes Against Children Task Force officer downloaded 2 files of scam from the user of Duggar's IP address at his used car business. Law enforcement officers with the Department of Homeland Security Investigations executed a federal warrant to search the premises on November 8, 2019, and encountered Duggar on the property. Prior to being formally interviewed, Duggar asked if someone had been downloading child pornography, despite no outward indication of the nature of the search. During a later post-Miranda interview, Duggar admitted to being familiar with peer-to-peer programs, specifically mentioned Tor, and acknowledged that both were on his computer at the car lot. At that point, law enforcement was unaware that Duggar had also downloaded Scam via Tor. A forensic examination of Duggar's computer in the office on the lot uncovered evidence that he had installed a password-protected Linux partition on the device and had used the partition to download Scam using both uTorrent and Tor. Significantly, the default Windows partition contained an internet monitoring software known as Covenant Eyes, but not the Tor browser or uTorrent, while the Linux partition contained the Tor browser and uTorrent, but not Covenant Eyes. Additional forensic evidence recovered from Duggar's seized Apple iPhone and Apple MacBook laptop confirmed that Duggar was the individual using the computer to download Scam, including evidence showing that the password to the Linux partition is one that Duggar used for years on his personal accounts. Put simply, Duggar went to great lengths to obtain Scam. The mere fact that he downloaded specifically a Linux partition on his work computer reflects his desire to obtain Scam and at the same time conceal and therefore prolong his ability to engage in this conduct. At the very least, Duggar had to conduct research in order to determine that the Linux partition was required to defeat Covenant Eyes internet monitoring. And then he went through the effort to download, install, and password protect the partition, all to avoid detection. Duggar, perhaps more than any other individual presented to this court, was willing to go through exhaustive efforts to obtain Scam without detection. Duggar's criminal activity was also deliberate and precise. Almost as soon as he set up the Linux partition, he downloaded and installed the Tor browser, which he promptly used to download and view Scam. He next downloaded and installed uTorrent, which he promptly and repeatedly used to do the same. Duggar also downloaded the VTC player to view his Scam, and after he viewed them, Duggar deleted all videos and images to further conceal his crimes. While his efforts to delete evidence may have succeeded to some extent, the forensic examination of his devices make at least one thing clear. Duggar did not stumble across Scam on the internet accidentally. To the contrary, the evidence reflects an individual who went to great lengths to conceal his online activity and who had the specific purpose of seeking out, downloading, and viewing Scam. In light of Duggar's considerable and targeted efforts to engage in criminal conduct he has been convicted of, the government submits that a sentence consistent with the guideline ranges is appropriate here. Duggar's history and characteristics. At present, Duggar is a 34-year-old male with no criminal history. However, the facts produced in pretrial hearings and at trial establish that he has previously molested 4 minor females, either while they were sleeping, hence incapacitated, or too young to understand what Duggar was doing or defend themselves from his criminal behavior. And while Duggar is not before the court to be sentenced specifically for this conduct, his past behavior nevertheless provides an alarming window into the extent of his sexual interest in children that the court should consider at sentencing. This past conduct, when viewed alongside the conduct for which he has been convicted, makes clear that Duggar has a deep-seated, pervasive, and violent sexual interest in children and a willingness to act on the interest. A guidelines sentence is warranted to appropriately account for his history and characteristics. The need for the sentence to reflect the seriousness of the offense. It is beyond dispute that crimes involving the trafficking of child pornography are incalculably serious and warrant significant sanctions. Fuck yes, they do. As the victim impact statement submitted with the PSR shows, and as long-term studies confirm, sexual abuse is grossly intrusive in the lives of children and is harmful to their normal psychological, emotional, and sexual development in ways which no just or humane society can tolerate. The fact that Duggar's conduct of conviction does not involve him committing hands-on acts of child sexual abuse does not lessen the significance of his predatory and criminal behavior, particularly in light of his past conduct described above. Contrary to what some defendants may suggest, trafficking in child pornography inherently involves the sexual abuse of children, even if no new child pornography is produced. Indeed, far from being victimless, trafficking in child pornography harms children in part because it drives production of child pornography, which involves child abuse. Trafficking in child pornography also results in perpetual harm to the children who have already been sexually abused, all of whom are grappling with the indelible trauma caused by the abuse. As another court noted, it is well established that children featured in child pornography are harmed by the continuing dissemination and possession of that pornography. Such images are a permanent record of the children's participation, and the harm to the child is exacerbated by their circulation. United States v. Burgess. Accordingly, every instance of viewing images of child pornography represents a renewed violation of the privacy of the victims and a repetition of their abuse. Adam Walsh, Child Protection and Safety Act of 2006. Recognizing that the possession, receipt, and shipping of child pornography directly victimizes the children portrayed by violating their right to privacy and in particularly violating their individual interest in avoiding the disclosure of personal matters. These children, who must live with the knowledge that adults like the defendant can pull out a picture or watch a video that has recorded the abuse of them at any time, suffer a direct and primary emotional harm when another person possesses, receives, or distributes the material. Let me just insert my motherfucking unsolicited opinion real quick that if you think that watching or distributing or possessing child pornography is a victimless crime, fuck you. Okay, now back to the paperwork. It is therefore unsurprising that when one mentions the term child pornography to your average American, he responds with the immediate disgust and a sense of unease. But as the Cunningham court warned, once it enters the legal system, child pornography undergoes sterilization, far beyond properly removing emotion from sentencing decisions. Images are described in the most clinical sense. Victims all too often remain nameless. The only emotions on display are those of defendants, sorry that their actions were discovered by law enforcement. Thus, while the written excerpt below cannot fully capture the suffering Duggar's crimes have inflicted, it is important to highlight the pain his predation caused in the words of his victims, or in this case, their parents. As the parent of one of the victims depicted in the scam the defendant downloaded explained, her daughter became an anxious and fretful shadow of her former self after being sexually abused, and when addressing the harm caused by offenders like Duggar, who traffic in images depicting the worst moments of her daughter's life, she wrote this: "I can find no words to express the fury I feel at those who participate in this evil, or my scorn for any attempt to minimize the responsibility by feeble claims that the crime was victimless. My daughter is a real person. She was horribly victimized to provide this source of entertainment. She is exploited anew each and every time an image of her suffering is copied, traded, or sold. While the crime is clearly conscienceless, it is hardly victimless. I asked my daughter what she most wanted to ask of the judge. Her request: please don't let them pretend no one's getting hurt. She had some words for the defendant as well. Don't you know no one should do that to a little girl? Don't you know it hurts? As the mother of a child victimized by this crime, I would ask that the court take into consideration the damage done by this heartless crime to my daughter and others like her, including those children who still wait for someone to rescue them from their exploitation and have no one here today to speak for them, and impose a sentence that takes into account the full impact of the crime on these victims. Those are the words of just one parent, of just one victim. There are many more victims of Duggar's crimes, all of whom were subjected to extreme and unimaginable instances of sexual abuse and violence. Some of the victims depicted in the scam he downloaded and possessed, like the victim described above, have been identified and rescued. Others have not, and the pain and trauma they have experienced as a result of Duggar's conduct will go unvoiced at the sentencing hearing. Considering the extremely serious nature of the defendant's offenses and the irreparable harm he has caused to the victims of his conduct, the government submits that a guidelines compliant sentence is appropriate here. The need for this sentence to afford adequate deterrence and protect the public from further crimes. The sentence in this instant case, if nothing else, must further the goal of protecting the public, specifically the most vulnerable members of the public, children, from further crimes committed by Duggar and others like him. Indeed, as a general matter, the deterrence objective of sentencing is particularly compelling in the child pornography context. Imposing a lighter sentence on one convicted of a sexual pornography offense tends to undermine the purpose of general deterrence and, in turn, tends to increase in some palpable, if unmeasurable way, the child pornography market. It is also surely reasonable for the state to conclude that it will decrease the production of child pornography if it penalizes those who possess and view the product, thereby decreasing demand. And the need for specific deterrence is particularly high here, although it has been widely reported and acknowledged by Duggar and his family in the public sphere, and yet still particularly contested throughout this prosecution. Duggar sexually abused multiple children when he was a juvenile. His victims, 4 in total, were all prepubescent females, including several who were significantly younger than Duggar. And now, similarly, the victims depicted in the scam that Duggar has been convicted of downloading and possessing were all girls, all of similar age, and all being sexually exploited. This is not coincidental. Instead, it should be seen as the singular most important factor for the court to consider in imposing sentence. As argued above, Duggar's guideline calculation includes an enhancement for engaging in pattern of activity involving child sexual abuse. The referenced pattern that Duggar has followed, and which is now before this court, involves his hands-on abuse of minor females, followed up by his acts to obtain imagery reflecting the hands-on abuse of minor females. At base, this pattern reflects a clear and long-standing sexual interest in prepubescent females, and, troublingly, this sexual interest in children has gone and will likely continue to go based on Duggar's conduct throughout this case, unacknowledged and thus untreated. I know that's motherfucking right. Unacknowledged and thus untreated. If that doesn't sum up this fuckery of a family, then I do not know what will. Unacknowledged, yes, absolutely. Everybody knew while at the same time pretending that nobody knew. I'm talking an abundance of people knew and yet turned a blind eye. I don't know shit about fuck. I don't know nothing. Don't see anything. Not gonna stop it. Not gonna get help for it. Whatever. And then thus untreated because everyone's in denial about what's going on, while also claiming to the entire fucking planet that they seeked help and treatment from a place which, by the way, had no medical health professionals, no mental health professionals. The very fucking definition of unfucking qualified might as well have sent his ass to fucking summer camp. I mean, if that does not sum up this family, then I don't know what will. And I can tell you from the documents that I have already previewed to read for upcoming episodes that the unacknowledgement is still motherfucking going on. Like, the denial, you can't make it make sense. You cannot make these people and their fuckery make sense. But I digress. Back to the paperwork. To be sure, Duggar certainly has a right to trial and a right to maintain his innocence. But this court is now presented with an offender who has a history of sexually abusing minors, who has not received any treatment or therapy for this conduct to speak of, who appears unlikely to ever seek out or meaningfully participate in treatment or therapy. Ooh, they are trolling him. I love it. To address this conduct, and who continues to deny any responsibility for his past or present crimes. Oh my God, yes. There is simply no indication that Duggar will ever take the steps necessary to change this pattern of behavior and address his predilection for minor females. Given these circumstances, this court should be particularly mindful in crafting its sentence of the likelihood that Duggar reoffends upon his release from incarceration and what his reoffending conduct will entail. Perfection. Of particular concern with respect to Duggar's likelihood of recidivating is the context of the scam he downloaded and possessed. Distressingly, the market for child pornography has continued to grow and to become more depraved in recent years. That depravity is evident here. As noted above, Duggar sought out images and videos depicting prepubescent minors being subjected to sadistic and masochistic abuse. And while the court has undoubtedly and unfortunately encountered other cases in which the sadistic or masochistic conduct enhancement applies, it must be acknowledged that the enhancement applies to a range of material, and the material Duggar sought out falls on the far end of that range. The scam he received and possessed not only depicted minors with similarities to his prior hands-on victims, I repeat, the scam he received and possessed not only depicted minors with similarities to his prior hands-on victims, but it also depicts minors forced into bondage, placed in cages, and subjected to extreme acts of violence, including being whipped and posing nude with what appears to be simulated blood and a knife. In fact, the forensic evidence presented at trial included multiple torrent files related to a series of scam that has repeatedly been described by law enforcement as being among the worst of the worst. The need for effective deterrence through a significant sentence is therefore essential here. After all, as the Supreme Court reasoned, the most expeditious, if not the only practical method of law enforcement to halt the exploitation of children may be to dry up the market for child pornography by imposing severe criminal penalties on persons selling, advertising, or otherwise promoting the production. A guidelines sentence is additionally appropriate given the grave concerns over the high rate of recidivism among convicted sex offenders and their dangerousness as a class. Smith v. Doe, see also Cunningham, discussing recidivism studies. There is no reason to think that Duggar is a low risk to recidivate. All his perverse activities were carried out in secret, and it is clear that he receives sadistic pleasure from the sexual exploitation of minors. But even if he could be described as a low risk to recidivate, a low risk is not the same as no risk. Adequate protection is a function of two variables: the level of risk that conduct will occur and the level of harm that will be inflicted if that conduct does occur. The sadistic nature of much of the child pornography consumed by the defendant is another reason to worry about his being on the loose. Given Duggar's history of sexually abusing minors and the sadistic nature of the scam he downloaded and viewed, in this case, it is imperative that the court's sentence be designed to ensure he does not reoffend. A guidelines-compliant sentence of 240 months will best ensure that outcome. The need to avoid unwarranted sentencing disparities and provide a just punishment. Given the specific facts of this case and Duggar's history of committing hands-on offenses against minors, the government submits that a sentence of 240 months is warranted here to avoid unwarranted sentencing disparities with similarly situated or less aggravated offenders. By way of comparison to other cases that have come before this court, in United States v. Brian Carey, the defendant, who was convicted by a jury of transportation and access with intent to view child pornography, was sentenced to a 180-month imprisonment. In Carey, the defendant emailed himself from one email account to a second email account, images of scam, conduct for which he did not receive an enhancement for distribution. Notably, Carey, like Duggar, did receive the pattern of activity enhancement. Specifically, when he was 19 years old, Carey was convicted in state court of a crime similar to production of child pornography involving an approximately 16-year-old victim. While admittedly similar with respect to guideline enhancements, there are several aggravating factors present in the instant case that were not in the Carey case, including, first, as noted above, the defendant did not distribute scam to others and thereby perpetuate the exploitation of the minors depicted in the scam, as Duggar did, second. The offense conduct in Carey involved approximately 100 still images of child pornography, as opposed to Duggar, who downloaded multiple video files, including video files depicting adult men vaginally penetrating prepubescent minors. Third, the evidence produced at trial reflects that Duggar sexually abused 4 separate minor females over an extended period of time, as opposed to Carey, whose conduct, however offensive, was limited to a single minor victim. Though less similar, in United States v. Jeremy Kelly, the defendant was convicted by a jury of multiple counts of receipt and possession of child pornography and was sentenced to serve 124 months imprisonment and 15 years of supervised release. Kelly, like Duggar, used a peer-to-peer program to download multiple videos. Approximately 19 distinct videos were introduced at trial depicting scam. Importantly, while Kelly had a criminal history score of 1, he had no prior conduct involving the sexual abuse of minors and therefore did not receive the pattern of activity enhancement that is applicable here. And lastly, in United States v. Robert Davis, the defendant, an approximately 20-year-old male with no criminal history, pled guilty to 1 count of receipt of child pornography and was sentenced to 100 months imprisonment. In particular, Davis exchanged images via social media application/internet community that depicted minors as young as 5 years of age and also maintained an organized collection of scam. Duggar's conduct is marked by a number of aggravating factors not present in the above cases. As an initial matter, Duggar used multiple means, uTorrent and Tor, to search for and download scam of a sadistic nature, including scam depicting prepubescent minors being subjected to violent abuse. Moreover, he went to great lengths to conceal his conduct from others, presumably so he could engage in it undetected and undeterred. As described above, over multiple days, he downloaded and installed a partition to his work computer in order to bypass internet monitoring software and then exclusively used that partition to surreptitiously download and install programs to obtain scam. When viewed alongside his molestation conduct from approximately 2013, Duggar's offense conduct here makes it clear that he became a savvier child sex offender in the intervening years, using sophisticated techniques to conceal and presumably prolong his ability to engage in this behavior. Fortunately, he was caught and convicted, but it appears that he is more likely to view his conviction as evidence that he needs to learn more sophisticated techniques to avoid detection in the future, as opposed to an opportunity to reflect on his years-long pattern of criminality and abuse. Oh, hot damn, they're getting it. Accordingly, to provide a just punishment and avoid unwarranted sentencing disparities with similar offenders in the Western District of Arkansas, the United States submits that a guideline sentence of 240 months is appropriate here. In conclusion, based on all the reasons discussed above, including Duggar's history of sexually abusing minors and the grave risk associated with his potential to recidivate, the United States submits that a guideline compliant sentence of 240 months is appropriate here. And that's a wrap for this episode. I will see you all on the next episode where I read the defense's motion where they have the fucking audacity to ask for only 5 years. So I will see you guys on the next episode.